Okay, let's unpack this. Imagine you are tangled in a legal dispute that takes years or maybe even decades to resolve.
Right, which happens all the time.
Exactly. You're bleeding savings, your energy is completely drained, and every time you think it's finally over, well, another motion gets filed.
Oh, it's a nightmare.
It really is.
Right.
For millions of people navigating traditional legal systems around the world, this isn't just some, hypothetical nightmare. This is their everyday reality.
Yeah.
But what if there was an entirely alternative route? Like a system proving that you don't actually need imposing wooden benches or strict procedural gavels or millions of dollars to deliver justice.
Right, a total different paradigm.
So welcome to today's deep dive. We are taking you straight into a massive engineered system designed to bypass that traditional nightmare India's alternative dispute resolution landscape, or ADR.
And it is a fascinating ecosystem to explore because when we, picture justice, we almost universally picture the grand architecture of a traditional court.
Oh, for sure. The big pillars, the judge looking down at you.
Exactly. We picture that elevated bench, the intimidating rules of evidence, and the heavy financial burden. The traditional model is inherently adversarial.
Right. Two sides enter, they fight, and the system declares a winner.
Precisely. But the landscape we're looking at today flips that entire premise on its head. It operates on the radical idea that justice can be speedy, inexpensive, and, incredibly accessible for the common citizen.
And to really grasp how ambitious that is, you have to consider the scale, right?
Mhm.
We're talking about a country with over 1 billion people and a famously backlogged judicial system.
Oh, massive backlogs. Decades long, sometimes.
Right. You can't just throw minor procedural tweaks at a backlog that massive. You have to invent an entirely new parallel system.
Yeah, you do.
But, you also can't just build a parallel justice system out of thin air without a rock-solid legal foundation.
Which is where the fundamental promise of the Indian Constitution comes into play, because a justice system is only as effective as its accessibility, right?
Makes sense?
If only the wealthy can afford the fees to litigate a claim, well, then the law isn't an instrument of justice at all. It basically functions as a luxury good.
Wow, yeah. A luxury good. That's a great way to put it.
And the framers of the legal frameworks we're looking at, they recognize that equality on paper means absolutely nothing without equality in practice.
Which brings us to Article 39A of the Indian Constitution. This essentially serves as the mission statement for this entire alternative landscape.
It's the bedrock.
Yeah. It explicitly mandates free legal aid for the weaker sections of society. The goal is to ensure that absolutely no citizen is denied opportunities for securing justice simply because of economic or, other disabilities.
And this isn't just a suggestion, right?
No, not at all. It's heavily backed by Articles 14 and 22, Clause 1, which guarantee equality before the law for everyone.
But to actually operationalize that constitutional promise, the government had to build an infrastructure.
Right. They needed a framework.
Exactly. So in 1987, they enacted the Legal Services Authorities Act. And this officially birthed a nationwide network, bringing NALSA, that's the National Legal Services Authority, into effect a few years later in 1995.
Then also. Right.
Yeah, NALSA acts as the umbrella organization that dictates policies and funnels funding into legal aid programs across every single state and district.
And the scope of what they consider free legal aid is what really stands out here. Like, if you're struggling financially, they aren't just offering you a quick 10-minute consultation with a public defender and sending you on your way.
Oh, no, it's comprehensive.
Yeah, it covers the entire life cycle of a legal proceeding. We're talking about the state absorbing your court fees, the process fees, the lawyer fees, and even the preparation and drafting of legal documents.
Because NALSA deliberately cast a massive safety net. They didn't just look at a strict income threshold. They looked at societal vulnerability as a whole.
Right.
So the eligibility criteria automatically cover women, children, members of scheduled castes and scheduled tribes, and, industrial workers.
And it goes beyond that, too.
It does. They also cover victims of mass disasters, ethnic violence, or earthquakes.
Because the state recognizes that trauma itself is a profound barrier to justice.
Exactly.
If you're a victim of human trafficking or a disabled individual, or you're currently in custody, you are automatically eligible.
Yeah, no questions asked.
And for the general public, there's an income threshold, generally applying to individuals earning under 1 lakh rupees annually, though I think that limit stretches to 5 lakhs if your case goes all the way to the Supreme Court.
Right. And the underlying philosophy here is that legal disenfranchisement is a critical societal emergency.
Okay, an emergency.
Yeah, because when a person's fundamental rights are violated and they can't afford to fight back in a court of law, the social contract is essentially broken.
You know, it makes me think of a legal emergency room.
Oh, I like that.
Right. Like if you walk into a hospital with a broken arm, a functional society doesn't check your wallet before stabilizing you. They treat the injury because leaving you to suffer damages the health of the community.
That's a perfect analogy.
The state is stepping in here and saying, we will provide the funding and we will provide the legal experts to make sure your crisis is triaged and treated.
And that triage concept is crucial because while offering free lawyers solves the financial barrier, it doesn't really solve the logistical nightmare.
How so?
Well, if the state just funds thousands of new cases and dumps them into the exact same traditional courts.
Oh, right. You're just adding to the pile.
Exactly. You haven't solved the problem at all. You've just added more bodies to a line that already takes decades to move.
So you have to divert the traffic. You need a place for these citizens to go where they won't be trapped in endless litigation.
Yes. And that is where the Gandhian philosophy of the look Adalat comes in.
Look, Adalat.
Yeah. It translates directly to people's court. It's deeply rooted in ancient Indian traditions of dispute resolution, long before the British formalized the current adversarial system.
Right, a much older way of handling things.
Exactly. Modern iterations started as an experiment, really. The very first Look Adalat camp was held in the state of Gujarat back in 1982.
And it started purely as a voluntary conciliatory agency. Like there was no formal statutory backing at all at first.
None.
It was just an organized attempt to get people to sit down and talk through their problems.
It's a conversation.
Yeah. But it was so wildly successful at clearing up disputes peacefully that the demand spread across the country. Eventually, the state had to absorb it, giving it statutory backing through that same 1987 Legal Services Authorities Act we just talked about.
And what's fascinating here is to understand why it works so well, you really have to look at who is sitting at the table.
Okay.
If you walk into a traditional courtroom, the architecture tells you exactly who's in charge.
Oh, yeah. The judge sits way up high looking down at you.
Yes, and the lawyers speak a language you likely don't understand at all. But a standard Look Adalat bench completely dismantles that hierarchy.
How does it do that?
Well, it usually consists of a serving or retired judicial officer acting as the chairman, joined by a lawyer, and crucially, a social worker.
A social worker. That's really interesting because adding a social worker to a judicial bench fundamentally changes the DNA of a legal proceeding.
It changes everything.
Right. A traditional judge looks at a property dispute and reads the deed.
Yeah.
But a social worker looks at that exact same dispute and analyzes the human dynamic. They recognize that legal problems are very often just symptoms of deeper social or interpersonal problems.
Which creates a profound psychological shift in the room. Regular courts operate on the premise that there must be a victor and a vanquished.
Somebody wins, somebody loses.
Exactly. But Look Adalats are engineered entirely around compromise. The presence of a social worker emphasizes that the ultimate goal isn't just to, enforce the strict letter of the law. It's to repair the social fabric.
Because if you're dragging your neighbor through a 10-year court battle, even if you win, well, you still have to live next to them.
It's awkward, to say the least.
That relationship is permanently destroyed. But if you settle that dispute in a Look Adalat through mutual compromise, there is no loser. The personal relationship often remains intact because you both, built the solution together.
But we should probably clarify that these aren't just friendly neighborhood advice panels, right?
They have real power.
They handle both cases that are already pending in regular courts and pre-litigation disputes.
Pre-litigation meaning?
Meaning conflicts that haven't even escalated to a formal lawsuit yet. You can literally nip the conflict in the bud before the paperwork ever gets filed.
See, wait, I do have to push back a bit on the mechanics of this, though. So if I'm arguing with my neighbor over a property line, we just sit down with a judge and a social worker and chat.
Basically, yes.
But how does anything actually get enforced? I understand the beautiful philosophy of a mediation circle. But if you're dealing with a serious financial dispute or a really stubborn opponent, just sitting down to chat sounds a little toothless.
I get why you'd think that.
Right, like if they're focusing on compromise, does this people's court actually have any real legal authority?
It has immense legal authority, actually. Under the Code of Civil Procedure of 1908, Look Adalats possess the exact same powers as a traditional civil court.
Wait, really?
Yes. If they need to, they can legally summon witnesses, they can compel you to show up and testify under oath, they can even requisition public records from any government office.
So they have the muscle to force the truth into the open.
They absolutely do. Their proceedings are legally recognized as judicial proceedings under both the Indian Penal Code and the Criminal Procedure Code.
Wow.
But there is a very strict boundary on their jurisdiction. They cannot hear cases involving what the law categorizes as non-compoundable criminal offenses.
Which makes sense. Like, if you're arguing over a broken fence or a breached contract, you can privately compromise.
Right?
But if you commit a violent assault or a murder, you can't just sit down and privately settle it with the victim's family over tea.
No, absolutely not.
The state considers serious crimes to be an offense against society as a whole, meaning they must be handled by the traditional punitive justice system.
Exactly. But for civil disputes, family matters, and minor compoundable offenses, their authority culminates in a very powerful final step.
Okay, what is it?
The award made by a Lok Adalat is legally deemed a decree of a civil court. It is final, it is binding, and, get this, there is no appeal against a Lok Adalat decision to any higher court.
Okay, here's where it gets really interesting, because I have to stop you there.
Yeah.
Stripping away the right to appeal sounds incredibly dangerous,
It does sound drastic.
especially for the marginalized people this entire system is supposed to protect. If a panel of 3 people pushes a bad decision on you, and there's absolutely no higher court to run to, aren't you just trapped by whatever they decide?
It would be dangerous if the panel had the power to force a decision on you. But they don't.
They don't.
No. A regular Lok Adalat can only pass an award if both you and the other party explicitly agree to the compromise. The panel facilitates the negotiation, they propose creative solutions, but it is entirely based on mutual consent.
Oh, okay, so you aren't trapped by the court. You're bound by your own agreement.
Exactly. If you feel the compromise is unfair or the other party refuses to budge, the Lok Adalat simply closes the file. The case goes straight back to the regular court exactly where it left off. You lose none of your traditional legal rights by trying the Lok Adalat first.
That completely flips the perspective. The lack of an appeal isn't a trap. It's a guarantee of finality once you have already agreed.
Precisely.
Because if you both willingly signed the settlement, what exactly would you be appealing? You'd just be dragging the other person back into the system out of spite.
The system guarantees that once you shake hands, the nightmare is truly over. And to make it even more attractive, it's structured to be entirely financially risk-free.
How so?
There are 0 court fees to file your case in a Lok Adalat. Better yet, if you had a case pending in a regular court and you already paid hefty fees there, but then you managed to settle the case in the Lok Adalat,
Let me guess, they refund you.
those regular court fees are fully refunded to you.
That is a massive structural incentive. The state is essentially paying you back for settling your differences peacefully and getting out of the traditional backlog.
It incentivizes collaboration over litigation. However, mutual consent is a brilliant tool when you have 2 relatively equal parties, like 2 neighbors or 2 small business partners.
Right.
It breaks down when there's a massive power imbalance.
Yeah, what happens when you're fighting a massive, faceless public utility company? Let's say the municipal water board is refusing to fix a major sanitation issue, or a power company overcharged you by a massive amount.
Which happens frequently.
A giant bureaucracy might just cross its arms and refuse to compromise, knowing they have the funds to stall you in a traditional court forever.
The legislature recognized that exact loophole. The voluntary nature of a regular Lok Adalat was a weakness when dealing with uncooperative public utilities. So in 2012, they amended the 1987 Act to create something specifically tailored for this problem.
And what's that?
Permanent Lok Adalats.
Permanent Lok Adalats.
Yeah.
These are specifically designed to handle disputes with public utility services.
Yes.
We're talking about transport like air, road and water postal services, telephone networks, power, water, sanitation, hospitals, and even insurance services. If you have a dispute with any of these massive entities, you can take it directly to a permanent Lok Adalat.
And they can handle significant claims. Initially, the financial jurisdiction was capped at 10 lakhs, but in 2015, they raised it all the way up to 1 crore rupees.
Wow, that's a huge jump.
It is, but the crucial distinction lies in how they handle a failure to compromise.
Because if the power company refuses to agree, you don't just get sent back to the regular court backlog.
No, you don't. In a permanent Lok Adalat, they still try to facilitate a friendly compromise first. But if conciliation completely fails, the tribunal has the statutory power to decide the dispute on its absolute merits.
So they can just make a ruling?
Yes. They review the evidence, they take a majority vote, and that decision is final and binding on both parties, whether the utility company likes it or not.
That is an incredible leveling of the playing field for the average consumer. It prevents a large public utility from bullying you by endlessly delaying proceedings. They're forced to engage, and they are forced to accept the outcome.
And we are seeing this deployed on a staggering scale. The government coordinates national Adalats, which are massive single-day events held simultaneously across the entire country.
Really, like a National Justice Day.
Exactly. Since 2015, they've even themed these national events, focusing entirely on specific types of cases like, say, traffic challenges one month and bank recoveries the next to maximize efficiency.
You also have mobile luck Adalats. These are multi-utility vans, physically equipped like small courtrooms, that literally drive into neighborhoods to resolve disputes on the spot.
It's amazing.
They're putting justice on wheels and driving it directly to the people.
Which raises an important question about reach, right? We've seen how ADR handles massive public utilities and broad civil disputes, but how does this conciliatory philosophy adapt when it comes to the most intimate, sensitive issues like family disputes?
That's a good point.
Or when it needs to reach the most remote, rural areas of the country?
Let's look at family matters first. The Family Courts Act of 1984 mandated the creation of specialized courts in cities with a population over 1 lakh.
Okay.
These specific courts handle marriage, divorce, custody, and alimony. And the entire tone of a family court is intentionally engineered to be different from a standard civil trial.
It has to be, because family disputes are emotionally volatile.
Extreme.
In a normal adversarial court, the strict rules of evidence practically force you to aggressively tear down the other party on the stand to win your case. Like, if you're fighting for custody, you are incentivized to destroy your former partner's character on public record.
Which is incredibly traumatic, especially if children are involved. Even after the gavel falls, you still have to co-parent with this person you just legally eviscerated.
It's terrible, and that's why the Family Courts Act explicitly demands that the court must attempt conciliation first.
They have to try to settle it peacefully.
Right. It creates a much more informal atmosphere, completely bypassing those rigid, intimidating rules of evidence. And crucially, they frequently bring in medical and welfare experts to assist the judge.
Because they recognize that a custody battle or a divorce isn't just a legal puzzle to be solved.
Right.
It's a profound human crisis that requires careful psychological handling.
It's about protecting the individuals from the trauma of the process itself, but, that still leaves a geographic gap.
How?
Family courts are mandated in larger cities. If you live in a remote village, traveling to a district headquarters to access a court isn't just buying a bus ticket. It means navigating an alien bureaucracy and losing days of wages just to show up.
Oh, that makes total sense. That geographical barrier is exactly what the Graham-Nyalayas Act of 2008 was designed to eliminate. Graham-Nyalaya essentially means village court.
Village court, right.
Yeah. This initiative takes justice out of the cities and brings it to the absolute grassroots, right down to the panchayat level.
And if you were to walk into one of these village courts, you wouldn't just see an unqualified volunteer making guesses about the law.
No, not at all.
The presiding officer, called the Nyayadhikari, is a strictly appointed first-class magistrate. You're getting top-tier judicial expertise.
But delivered in a highly accessible format. These are essentially mobile courts. The magistrate physically travels to the villages to dispose of cases where the people actually live and work.
And they handle both civil and criminal matters, but they use a highly simplified procedure.
One of the most fascinating aspects of the Graham-Nyalayas is how they handle evidence. Instead of being strictly bound by the complex 19th century rules of the Indian Evidence Act, these village courts are guided by the principles of natural justice.
Natural justice, that essentially means fairness, equity, and common sense.
Right.
Because in a highly formalized court, a completely valid claim can be thrown out just because a piece of paperwork was filed a day late or a specific technicality wasn't met. That rigid formalism is a massive barrier for the rural poor.
Exactly. So what does this all mean?
Okay.
By prioritizing natural justice, the focus shifts entirely to finding the truth and delivering a fair, swift resolution, rather than getting bogged down in procedural red tape.
It's brilliant. If we pull all these disparate threads together, the Indian alternative dispute resolution landscape tells a very cohesive, powerful story.
It's like shifting from a centralized, intimidating hospital where you have to wait for days to a network of visiting doctors who come directly to your living room to heal your specific ailment.
I love that. You start with NELSA, acting as the first responder, stepping in to guarantee free legal aid to the marginalized so no one is priced out of their own rights.
Then you have the look at Adalats, shifting the paradigm from adversarial combat to binding, compromise-driven decrees and, refunding your fees as a reward for peace.
You have the permanent look at Adalats, leveling the power dynamic against massive public utilities.
Right.
And the traveling magistrates of the Gram Nyaleas ensuring geography doesn't deny you a fair hearing. It's a massive, highly engineered effort to bypass the labyrinth of traditional courts.
It proves that the constitutional promise of speedy and inexpensive justice is actively being built, refined, and deployed to millions of citizens who would otherwise be left waiting in the dark. It is a profound reimagining of what conflict resolution looks like at a systemic level.
And that is something for you to keep in mind. If you ever find yourself facing a legal hurdle, remember that justice doesn't always have to look like a gavel banging loudly in a daunting, expensive courtroom.
Right. There are other ways.
Sometimes justice looks like a conversation across a simple table, guided by the community, aiming for mutual respect rather than total destruction. It's a reminder that the law doesn't have to be a weapon, it can be a bridge.
Which leaves us with one final provocative thought for you to ponder. The look-ballot model proves unequivocally that shifting from an adversarial winner-takes-all mindset to a collaborative, compromise-based approach saves years of time, massive amounts of money, and preserves vital human relationships.
It really does.
So if this Gandhian philosophy is so incredibly effective at clearing nationwide legal backlogs and solving complex disputes against massive corporations, why is our default societal instinct still to immediately point a finger and scream, "I'll see you in court"?
It's a great question.
What would actually happen to our communities, our workplaces, and our own personal stress levels if we applied this conciliation model to our everyday personal conflicts long before the law ever had to get involved? Think about it. We will see you on the next deep dive.